areas that you wanted to review. And from there, hopefully we can have some time to answer questions, and questions could always be emailed as well. So don't feel like this is it. This is, you have to ask today. We're always around to ask those questions.
That's absolutely right.
So without further ado, I think we only have an hour. We don't want to take up too much of everyone's time. And I think it might be doable. Let's see what we could get done in 1 hour.
Okay, great. Did you want to have the CAC members introduce themselves, Laura? And just as a reminder to everyone, we are recording this meeting. So this is being recorded starting about 30 seconds ago. So, and this is for posting on our YouTube page.
Yes, indeed. And I can't see faces, but I'm assuming I have not met everybody. My name is Laura Romero, and I work for the Facilitator Self-Help Office. And so I'm one of the members of Court Advisory Committee. We have a few others here. I think I saw Nuala.
Yep.
Nuala, are you here?
You're muted, Nuala.
Letting me unmute. There
you go.
Hi, I'm Nuala Bates. I'm one of the more recent members of CAC. I'm a supervisor at the Court Investigators Unit.
Wonderful. I don't see any other CAC members, do you? Unless they're joining by phone. If there's a CAC member, can you unmute and introduce yourself? Okay, looks like not. Just so everybody's aware, your other CAC members are Ravi Ganji from ISB, Steve Gall from ISB, Georgia Koo from Facilities, and who am I missing? Oh, Brandon Kanimura, also from ISB. Okay, wonderful. Well, welcome everybody. As Laura mentioned, this is probably an overdue review of the contract. I have posted in chat a copy of the contract. So if you can bring that up, that would be great. I will be sharing my screen as well, but what I'm going to be sharing is not that contract. What I'm going to be sharing is a summation of what I'd like to review. And I've broadly categorized it in 2 categories. One is changes to the contract, so we can review those. And then the second is making the most of your contract. And that's split into 2 categories. One is economic benefits, money, right? The do-re-mi that a lot of people are interested in. And then, of course, non-economic benefits like how can I telework? How can I get a class review? What are the timelines for applying for a voluntary reduced work hour and things of that nature? So let me go ahead and share that right now. Thank you for that, Ms. Hamlin, explaining that Brandon and Ravi are on furlough today. As people join the Zoom call, they will not be able to see the PDF that I have included. So Laura, could I ask you to post that every 10 minutes or so? To repost that PDF I just put in chat?
Hello.
You are muted, but I'll try to do that if I see you nodding. Thank you. Okay, so I'm going to share my screen right now. Oh, is someone trying to talk? No, okay. I'm going to share my screen right now so you can see the summation, and please follow through with the contract itself. So what I'm going to start out with, and here's the format that I've put this in. 2.1 means section 2.1 of the contract, right? So I'm going to start off with, I'm going to give you a brief overview here. Maximizing your benefits. As I mentioned, we've got monetary programs here. This is a lot of information I'm going to be throwing at you guys. So feel free to ask clarifying questions at any time or email after the fact. Then I'm going to be talking about the Union Advantage, which is non-monetary items. And then I'm going to be covering changes for the 2020. This really should say 2019. I'll say for this contract. And many of these we will have covered earlier, but I just want to make sure that we do hit all the high points. All right, so let's jump into it. How to maximize your benefits. Okay, well, the first thing is section 2.1, which is salary, right? This is a key item that everybody always talks about as their #1 priority. What do you want out of the contract? a pay raise. So I'm happy to report that we were able to secure a 3% wage increase every year for 3 years. You could see that in the document here. If you follow along in section 2, you can see effective the first pay period of 3%, August 1, 2020, August 1, 2021, 2022, 2023. So for the life of the agreement, you're getting a 3% pay increase in the summer, August 1, in that pay period. So that's a big one. Another big one is pension. And this we could spend a whole hour talking about. So this is going to be a pretty abridged version. There are 2 tiers of pension. One is called Classic and one is called PEPRA. Classic is anyone who was hired on or before January 1, 2013. And these folks are in the Classic tier. What that means is that your benefit is 2.5% at age 55. And you can contribute, or you not can contribute, you are required to pay 8% of your salary. So Cliff's Note version, what does that mean? Okay, we're in a CalPERS program, which is what's known as a defined benefit program. The defined benefit is 2.5%. I'm going to use a round number of $100,000. So if you make $100,000 a year, for every year that you are employed by the court, you accumulate 2.5% of your salary. If you work for 10 years, 10 times 2.5 is 25%. If you retired at age 55, you would receive 25% of your final salary every year for the rest of your life. In order to pay for that benefit, you're contributing 8% of your salary. In my example, you're making $100,000. That means you're paying $8,000 a year. The court's contributing another 8%, a little bit more than 8% on your behalf. And that buys you that benefit. It's a great benefit. For those of you hired later, you're part of the PEPRA tier. Unfortunately, it's a legally mandated tier. We did not negotiate away this benefit. This was implemented by Governor Brown with the support of the state California legislature. PEPRA stands for Public Employee Pension Reform Act. You have, there's no way to sugarcoat this. You have a lesser benefit. Your benefit is 2% a year at age 62. Now you can all call CalPERS and see there's a sliding scale, and you can see if I retire early, you could retire at age 55. If you're in the PEPRA plan, you could retire at age 55 as well. Here you could retire at age 50, excuse me. And you can see how that would lower your benefit. You can still retire earlier, but then you get a lesser benefit if you draw. Now you're paying a slightly different formula. You're paying 50% of normal cost. Since PEPRA has been implemented, that's been cheaper than the 8% of salary. You're somewhere between 6 and 7% of salary typically. So you get a lesser benefit at a slightly lesser cost. Another big monetary item, retiree medical. So for those that were hired before 9/1/2017, you are having $22.50 per pay period deducted from your paycheck. And that's used to pay for the retiree medical plan, which really bridges the gap between the time that you retire and the time that you're eligible for Medicare. It's a much lesser benefit if you work a lot longer in the court. Let's say you work until you're 65. The retiree medical still pays for Part B, but it's not as significant. Okay. Post 9/1/2017, people who were hired after that, the court, rather than you participating in the retiree medical plan, the court is contributing $150 per month to your deferred compensation plan. Also, we had a couple, I think it was literally a couple, literally 2, who opted out in that one-time pay period and chose to get the $150, saying that they would never take advantage of the retiree medical. So you have a more robust deferred compensation plan for anyone hired after that date. Okay, oftentimes we get questions about educational reimbursement. In that document, the PDF that's attached, that's Article 6.1. You can read it for additional details, but what it covers is, broadly speaking, courses, classes, conferences, and publications. That means you could subscribe to a journal a law review, law review. You could, if there's something that's relevant, you're an accountant and you want to get an accounting publication, you could do that. You can attend conferences, classes as well. You can sign up for courses. Here's the situation though. It has to be approved by the CEO, and there's a 50% reimbursement up to $3,000 a year. And there's a $50,000 pot per year for SEMA. We've never exhausted this pot. Doesn't mean it can't happen, but we have not exhausted that pot to date. So if you're thinking about taking a benefit, you want to brush up on a particular skill, you want to attend a conference, be sure to put in for this. It's a great benefit. You're paying half the cost though. Remember, you're paying half the cost and the court is paying half the cost. Something that's really important to remember about this is exclusively for you. So you meaning your personal professional selection. Do not let your boss come to you and say, hey, look, times are tough. And our training budget got cut, but I know you still need to have this training for the court. Why don't you use your educational reimbursement program? Forget it. This is self-directed. If the court wants you to go to a training, they can pay for that training, and that's covered later on in the contract. I'll pause just for a second to see if there are any questions. I see there's some posts in chat. Okay. I'm
sorry, that was me just trying to repost, but I reposted the wrong document. Please disregard.
Okay, sure. Somebody is asking, I won't reveal your name, but if you can, post the questions publicly so everyone can see them rather than just to me. Sometimes there's reasons you want to keep your name confidential, so that's fine too if you need to post them directly to me. But let me just read this private question here. I am not. So here's the question. I think it's referring to educational reimbursement. Has there ever been a case where the supervisor doesn't forward your request? If there has been, I'm unaware of it. But that's certainly something that you should bring to. You can submit it directly to HR or copy HR at the same time that you send it to your supervisor, or escalate it to me if that's a problem. And in fact, I'll post my cell in the text right now. That's the best place to text or call me, especially now that we're working remotely for the most part. I hope that answered your question. So yeah, there used to be 100% reimbursement, JR, for different categories. Right now, 6.1 is addressing, it's a much larger pot. Let me see where 6.1 is here. It's a much larger pot, and we doubled the amount. So it used to be 1,500 maximum, and now it's 3,000. And you can make a special request. If you look at the very last paragraph, you can make a special request for more than 50% if it's unused.
Hi, my husband has been trying to call you guys and nobody's answered. So they're trying to get there. Yes.
Sorry,
and,
trying to get what?
Okay, he's been trying for over an hour or more and nobody's picked up.
Are you talking to me?
Yes, they're on their way. They're in the car. I'm at work trying to handle it, but okay.
I think you might be addressing a different phone call. Can we mute? Stacy, that's not directed to me, is it? Okay, please put it in text if this is directed to me. I'm muting you. I'm just going to mute all and allow you guys to unmute yourselves, so that way we don't have that. I don't believe that was directed towards us. Okay. Public Sorry, someone's posting in chat. Okay, thank you, Estella, for clarifying. That's the JAS unit, not HR. Thank you. Okay, the next item is public transit. This is where we're going to talk a little bit about timelines. So public transit, November 15th of each year, you notify the court of the need for court parking. So that's the first portion of this, is that the court will provide parking for you if you need it. And there's another window. I'm not going to go into the different variables of how you can get it if it's outside of November 15th. Suffice it to say, if you're hired into the court and didn't have an opportunity, you can request it. If you're transferred from one location to another, you can request it at times that are not November 15th. Also, in this benefit, you can get a commute reimbursement for public transit of up to $200 a month. It has to be public transit. So if you're just driving your own car, paying bridge tolls and stuff, that's not what this is designed to cover. It's designed to cover commutes that are outside of the next item, which you may also get. This is an either or. You can either get the Smart Pass or the Clipper card, or you can get the court provided parking. You can't get both. So you have to make that selection, and that persists from theoretically from one November 15th to another. So that's a mechanical benefit people get. Training fund. This is kind of a misnomer. I wouldn't so much call this one a fund as a program. There are in-house trainings through CJER that you are allowed to participate in. And this represents a move away from the so-called county-wise or SCC Learn when we were more closely linked with the county. So now house trainings you can request, or you can look up through CJER and use the courts mechanism to get some of those trainings. Ready assignments. So ready assignments is, sometimes people might refer to this as 24-hour pay. They might refer to it as on-call pay. It's all the same thing, is it means ready assignments. I'll circle back. I see there's a couple of questions here. I'll circle back to these in a moment after talking about ready assignment. So the court is really buying your availability after normal work hours. Now, after normal work hours means after your normal work hours. So sometimes people intentionally work a later shift. I think we have a couple of 1 or 2 night janitor supervisors or facilities supervisors that work a little bit later. Sometimes people flex their day to work a little bit earlier. So it's not, well, I picked up the phone at 6 if you normally start your workday at 6. It's that the court is buying your availability and your expectation of response before or after your normal workday. And you'll see that there are 2 tiers here based on the type of work that you're performing at either 5% of your salary or 3% of your salary. So let me go back and address some of these questions here that I see are coming in. Okay, Rowena asks, regarding educational reimbursement, the contract only states that professional memberships are subject to 50% reimbursement, not the actual classes. No, that's correct, Rowena, and I apologize if I didn't make that clear. The classes, courses, and conferences, hang on one second. Yeah, the classes, classes and conferences are eligible for up to 100%, and you are correct that professional memberships are reimbursed at a lower amount. Yeah, you're correct on that. So this should be reimbursed at 100% or 50% for memberships, I guess we could say. Thank you for that clarification. Brittany asks, can there be a discussion with the court about having another opt-out offering for retiree medical? You know what? I will ask Laura to include this on our discussion. We're having a court meeting after this, CAC meeting after this. I would say we can certainly ask. I suspect it would it's going to be a financial decision on the part of the court. Does it make sense for them to do it? Strictly speaking, our contract is set for another 3.5 years. So they could correctly respond and say, that's a legitimate topic of bargaining, bring it up in 3.5 years. Or we could offer a side letter. I guess I'd want to understand how many people are interested in that. I'm assuming by you asking for it, you're interested. Okay. Yes. Okay. You are, Brittany. All right. Good to know. And Chapman asks, how come the CRC supervisors have to answer phones from jail after hours without pay? I'm not sure what CRC is an acronym for. If you could help me with that, they shouldn't have to. If the expectation, thank you, courtroom clerk. If the expectation is that you answer after hours calls, then one of two things should happen. Either that expectation is removed and it's assigned to somebody that is getting after hours pay, or you don't pick up the phone, or you are compensated for it. So either you don't pick up the phone and you alert them, I'm not compensated for work outside of my routine job, and you don't get, you just don't pick up the phone after that announcement. And if you're uncomfortable sending that, I can send that announcement, or you get the compensation. Now, I want to be clear to folks, when we're talking about after hours contact, the key is that you are expected, directed to respond after hours, and there would be consequences if you don't. For instance, I will frequently take member calls 5:30, 6, 6:30, 7 at night. My boss is not going to get mad at me if I don't. I'm not going to be disciplined. The world isn't going to stop. I'll come back the next day. If you're a CRC supervisor and your boss is saying, I expect you to pick up the phone after hours, and if you don't, you get a talking to the next morning, or you get an angry email or something, then that's inappropriate. Sounds like you have a regular schedule that rotates through supervisors, then the pay should rotate through supervisors as well. So it sounds like we may have an issue on that. If you want to follow up with me separately, that would be appreciated, and we can bring it up at our next labor management meeting, or we can have an ad hoc meeting concerning that. But you should either not be getting the expectation and after hour calls, or you get the compensation. Yeah, just email me. Just email me the details on that, and copy Laura as well, if you'd be so kind. And we'll raise it probably we'll just alert HR to it immediately. I might ask you for more information, like who's involved and so forth. Okay. Let's see here. Where did I just leave off? Educational reimbursement, public transit, ready assignments. Okay. Payments, 9.3 covers payments for specific narrow certifications. You can see that there are a few differentials offered if you have those certifications. Bilingual pay, just so everyone knows, if you are assigned bilingual duties, then you are eligible for the $150 a month bilingual pay. Now, this means that you have to be assigned. It's not that once a month someone walks up to the counter and wants to speak another language, Tagalog, and you know Tagalog and just interact with them because it's simpler. Look, we all want to be helpful. I'm sure some people do that because they speak a second language, third language. You have to actually be assigned, and you're a resource for people for when the public comes in or calls and needs to have that. Several SEMA members are getting this payment, but probably others may be eligible as well. So if that's assigned to you by your boss, you're eligible for $150 a month. Lead differential. This was a feature of this most recent contract that was increased to 7.5% from 5%. Only a couple of work areas have leads. Leads provide guidance and may assign work. It's not the full spectrum of responsibility and supervision and management, but they can provide guidance and assign work in the various units where are represented. Right now, I think they're in the court mediators as well as in the self-help center There may be another one, a lead attorney somewhere as well, but there's only a few. Also, if you think this is necessary and you're a supervisor or manager in your area and you really need the support of a lead, you can request that kind of creation through your management. I don't know if the court has been creating it. Actually, I do know the court has not been creating any since the last contract cycle, but they may be open to that now. I don't know. Differentials don't stack. So this is just a notice to everybody. What I mean by don't stack, and it spells it out more clearly, is that I'm going to use my example of $100,000. Let's take this. Your lead differential. Say you make $100,000 and you're eligible for this differential. That means you get an extra $7,500 a year. Now, let's say you're also eligible for this ready assignment of 5%. It's not 5% on the now 107,500. It's 5% on your original salary, 100,000. So that's what it means by no pyramiding of differentials in that section. They don't stack. It's always based on your base salary. So you'd get 5,000 for this, you'd get 7.5% or 7,500 for this, and then 150. They wouldn't interact with each other and make each subsequent payment larger. Here's a big one that I want to make sure everyone's aware of. This is an economic benefit not everybody uses. Not this most recent contract cycle, but 2 contract cycles ago, we liberalized this. You used to not be able to use cash out time. You used to have to not use sick time or very limited sick time in order to cash out 40 hours of your vacation. Now you can cash out up to 40 hours every January. The month of January, you alert them, and then you're paid out in the month of February. JR is asking, isn't it up to 8 hours for 10.80 hours? Yes. Let me look at 8.1 now. I know you can't see me popping between windows, but that sounds correct. And that's a good correction. Thank you for that. 10.1. Yes. So it's 40 hours, or this really should say or 80 hours, right? So you could do 40 hours with, or you have the option for an additional 80. Excuse me, additional 40 for a total of 80. So I'll just read it. Cash out. You may cash out up to 40 hours of STO with an option to cash out an additional 40 hours. So I guess really it's probably cleaner to just say up to 80 hours. That probably will lead to less confusion. Yeah, but thank you for that. That is a good correction. We did send out a reminder for it. I'm not sure what, N. Chapman, I'm not sure what you are, when you say you wish you knew it, did you not receive the email, or did you mean you wish you knew that it had increased to 80 hours? Well, if you want to ask further about that, wish I knew I could use sick time. Oh yeah, so that's a benefit that we got 2 cycles ago, I believe. I don't believe that was covered in this cycle. Yeah, it was not. Oops, let me just. Okay, so, and we'll, I can commit to you and Laura and Nuala, let's make sure that we advertise this a little bit better next time. All of these windows that I'm talking about, and there's a couple windows here too, one of which is going to be relevant in just a moment, you want to be aware of. You cannot use sick time for the STO cash out. And that's exactly why it's called STO cash out. You think STO is equivalent for SEMA to vacation. You can only cash out STO. You can't draw down your management leave bank or your sick leave bank and get a payment for it. JR, if you can give me some suggestions as to how we could better advertise this, I'm very open to that. I know we covered it several times when we were voting on the contract, and then we covered it in the summary, and then we sent out an email about it. So I'm very open to trying to provide more updates, but if there's a way that we can break through so everyone's aware of it, I certainly want to do that. No, you cannot use sick time. What I did mention, that's right, you can only use vacation. Very technically, it's called STO, scheduled time off. Think of it as vacation. And you can only use that to get a payment for the STO cash out feature. It is in the MOU. It's section 10.1. You could see it right there at 10.1 in the document I included earlier. Union Advantage. Okay, so this is non-monetary items or marginally monetary items, but generally not cash in your hand, right? So here are some items that a lot of people ask about. Right now, we have VRWH. That's a component of our side letter dealing with the layoff protection. However, outside of these extraordinary times, right, where we have augments to the telework, which we'll talk about in a second, and VRWH along with layoff protection. Let's pretend these were normal times post-COVID. The voluntary reduced work hours is what this stands for. What it means is that you can reduce the amount of time that you work, and then you reduce the amount of pay you receive. If you work 5% less, you get 5% less pay, but you also get 5% more or less time that you're reporting to work. The recent change allows this to be up to 20%. It was previously capped at a lower percentage. And it's already had spelled out internally, but now it's included in the contract that it's in 6-month increments. So this is adds some flexibility and is now codified in the contract instead of it being a separate HR process. 7 is the training fund. We already talked about this. It really shouldn't be, I shouldn't have covered it in the monetary benefit because it's just that you can access the cost of, you can access free of cost court-sponsored trainings. 10F is a new addition to the contract, which is that leave requests, the supervisor or manager has 5 days to offer a conclusion or response. This is something that just highlighted the issue. It's not the language that we really wanted. The language we were seeking at the bargaining table was you have 5 days to respond or the vacation is approved. I haven't seen this issue crop up as frequently as it was before. And what I mean by this issue is people putting in for a request for time off and then management just simply not responding, whether it's an executive manager or in some cases a higher level SEMA person. For whatever reason, you're very busy. You don't want to give a response until the date is closer. And it was making it difficult for people to plan extended trips where maybe they had to buy plane or boat tickets or book a resort or something like that. So this is our effort to improve that. I categorize this as non-monetary, but really I feel that it does have a cash value. Your management leave, which is your third category of time off, STO, scheduled time off, which most people think of as vacation, sick leave, which is just that, sick time. And then your last category that's general is management leave. For those of you that have been here a long time, you probably remember that management leave was not a bank. It was you just asked for time off and your boss would approve or deny it. We had a lot of disparity as to how that was implemented. So a few years ago, we went over to a bank of 32 hours, and now we've increased that bank to 40 hours. So that's a full extra day you get off per year. I strongly, strongly recommend that this is the first bank you touch if you ever want unscheduled or scheduled time off. Obviously, if you're sick, you're sick. You call in and you can't do anything about that. But there's never a reason to not draw down your management leave bank first because it's a use it or lose it benefit. In fact, I'm just going to write that here. Use it or lose it. every year. If you don't use it, let's say you went through the whole year and used 30 hours of your 40, that 10 hours is just gone, right? So please, please do use these before you tap into your STO bank. Layoff procedures and protection. I'm not going to spend very much time on this because right now we have layoff protection through the end of the fiscal year. However, there's a great video that talks about this. I think it's already got 1,100 views that our county chapter has really spent a lot of time looking at because they actually did face layoffs, unlike the court, but it was very, very limited. In a unit of about 1,500, there were 11 layoffs. Nobody went out the door, but people moved around. And it was important for lots of people were concerned about this issue. So please click on this. Oh, let me post the link just so it's easy for everybody here. And then that way you'll be able to access that. Here we go. If you're interested in reviewing that after the meeting. Also, I wanted to briefly talk about an important chapter, which is Article 15, which discusses grievances. So grievances are violations of the law, county or city ordinance, which I characterize as law. A lot of lawyers on the call too, as well as a violation of the MOU, which is our contract. You have 10 days. Sometimes I can get around that with a date of discovery argument if I'm unaware of it. Oh, yeah, thank you. Someone is pointing out that this is, this should read increased to 40 hours from 32. I apologize for that. I'm not doing some sleight of hand here. You know, your ration of chocolate is increased from 2 grams to 1. No, it is a true increase. Thank you for that clarification, whoever just texted me. Thank you. Yes, please repost the red line if you would, just in case. I think we've had 14 or so people join afterwards. So the grievance process is a protection for you. If you're ever disciplined, and the court defines discipline as anything that results in a loss of pay, then we can grieve it. There are several steps to the grievance process. The first is you notify the employer of the grievance and you want to attempt to informally resolve the grievance. Sometimes that happens. Actually, quite frequently that happens with the court. We don't have to file a formal grievance. Then if we do file a grievance over an issue, we go to a pre-grievance meeting. The grievance is written up with the particular violation of the law, ordinance, labor code, most likely our contract. And then we have that discussion with HR and the court administration, executive leadership, and see if we can resolve it. If we can't, then we go to pre-arbitration and then arbitration. A couple of cases in the past few years have been settled through arbitration at the court. Only 2 that I can recollect, and that has benefited our members in both circumstances. One actually yielding a $30,000 payoff for somebody, as well as a restoration to their code. And also, grievances are discussed in the discipline process, which is coming right up in terms of discussions. So discipline is 16, Article 16. I want to just inform everyone of something called your Weingarten right. This is where you have the right to union representation. And if anything could lead to discipline, you have the right to union representation. So I would be present at the meeting. If I'm conflicted out, my colleague Adam or Mary or Michael would be able to stop into the meeting and represent you as well. And they'll guide you through the process, what to expect. I realize discipline is pretty rare in the SEMA unit, but when it does happen, I strongly urge you to get representation. Don't go in alone. So if your boss surprises you and says, hey, I want to have a discussion with you about, you know, how you messed up the Johansson case or whatever, the question to ask is, could this meeting result in discipline? If the answer is yes, you're legally entitled to union representation. The criteria is it has to be in a reasonable amount of time. Usually that's 2 or 3 weeks, right? I can't say I'm not available for 8 months, right? But as long as we're available pretty quickly, that's solid. So what happens if you get disciplined? Again, discipline meaning a loss of pay. So think suspension, demotion, termination. If you are disciplined, you have a right to an administrative hearing. That means that a court executive personality outside of that chain of command will hear the case. So it's not going to be the same person who authorized the discipline, right? For the sake of argument, executive A, manager A disciplines me, who's my boss, and they ran it through executive A. If I appeal this to an administrative hearing, executive A is not going to be sitting on that administrative hearing, right? We would get a different executive. They make a ruling. They uphold or reduce whatever the finding is, the discipline is. So they might say, hey, Zeb, I know you got suspended for a week. I'm not compelled by the evidence. I am recommending that you get a letter of reprimand. Then the CEO looks at that and upholds or rejects it. We can then appeal that ruling to the CEO. Unfortunately, the CEO is not going to disagree with themselves. We might present new information to the CEO that would cause them to change their mind. And then if they don't, we have the final option of arbitration, where we select from 5 neutral arbitrators with the court. We strike mutually, end up with one, and that arbitrator hears the case and issues a binding arbitration. So that's the full step process, assuming we think we have a strong case and want to carry it all the way through to arbitration. If it's a weak case for whatever reason, maybe we only go through the admin hearing and do the best that we can. But historically, we've either prevailed or gone all the way to arbitration. And the court does not have very many of these cases. Okay, so hopefully that gives you some peace of mind with regards to protection for disciplines. A classification review. This is coming right up. We're going to send you another reminder in March. So CAC members, I see a couple joined the call as well after we started. Remember to remind me that we want to send this out. If you want your classification reviewed, the window every year is March 1 to April 1. You can see some of the details in section 18. What this is you are saying, study my classification. Usually, it's because you think you are doing things outside of your class. So I'm going to stop the share for a second so you can see this visual aid. Pretend you say, this is my job spec, right? This is what I'm supposed to do. But this is my scope of duties. This is what I'm actually doing every day. And here's the overlap. Well, that's a really great case, right? In this example. If this is the overlap, you got a really bad case, right? So that's part of this process. You put in for the review and you talk to me, maybe you talk to one of the CAC members, or I'd probably have one of the CAC members shadow me so that they can learn more about this process. And we look through the different components of your job. We pull up your job description, see what fits, what doesn't fit, and then make the best case possible. Ideally, the strongest cases, as I mentioned, are where there's a big divergence in your duties, and there's another classification in the court that you can point to, right? So you can say, look, there's a big divergence in my duties. Right now, I'm a management analyst. I'm actually a court manager, because look at these duties I'm doing that squarely reside in the court manager role, right? Possibly that's not happening, but that's just an example I'm using. That's the cleanest. A less clean, but still possible result is, here's my duties. Again, the papers, they're really divergent, but that classification doesn't exist in the court. Whatever it is I'm doing, there's not a class that describes that right now. So make a class that describes my constellation of duties. It's an important feature of the contract. It's not often used. We're using it right now for a couple of cases, but something that is important for folks to use. And it can result in several things. Either it's upheld and you get the class that you want. It's upheld and the court gives you an alternate classification, maybe not the one you want, but usually it results in an increase in pay. They deny the claim or they remove duties to the point that you are appropriately classified. Okay. Article 19 is about compaction. And this is a 10% rule of thumb. You can look at Article 19 for additional details on this. Here's the sort of straw version of this feature of the contract. You should be earning 10% more base salary to base salary than folks you supervise. There are a couple of carve-outs to this, and I'll explain that in a second. But typically, you should be earning 10% more. If not, you'd put in for a compaction review, and the court should update your salary so that there is a 10% difference. I don't believe this exists in the court, but let me give you an example of how this exists in the county, where it is totally appropriate. In the county, there are classifications called ASMs, Administrative Service Managers. At the hospital, there are ASMs that supervise doctors and surgeons. I realize surgeons are doctors. Surgeons, let's call them. Well, a neurosurgeon is paid $400,000 a year. An ASM is maybe paid $140,000. The ASM cannot do the work of the doctor they are supervising. So they're not eligible for compaction. They don't have the skill set to do what the surgeon is being paid so much to do. So that's a peculiar example, but I just want everyone to be aware that there are carve-outs to that, where if you don't have the skill set to do the job of the folks that you're supervising, you may not be eligible for this. And there's no window on this. This you can apply for at any time. The telework side letter, I'm not going to review because that's in suspension right now, and we're a little bit short on time, but I did post that initially, and I will again for you to review. Right now, as you know, many people have been put on telework because of the COVID crisis, and that will likely continue until we have a high vaccination rate. The public health officer of Santa Clara County is estimating a 70% plus vaccination rate prior to suspending the work from home orders or stay-at-home orders. And then also, as a feature of our contract, we have the confidential employee side letter. I want to cover a few of the changes in the contract, and this shouldn't take long, and then we'll probably have 5-10 minutes for questions. The first is changes in this contract. 1.2, we got 2 weeks of notice for ready assignments. And then it also in this section, it includes that non-exempt employees, names a couple of classifications, are paid hourly. We picked up a few classifications that are non-exempt, read hourly, and that means they still get hourly pay and overtime. 1.4 means that there's an orientation guarantee for newly hired people. If that is not happening, please alert me so we can demand that from HR. It is a requirement. Or it may not be HR, the court. It's their responsibility. 1.5 talks about automatic eligibility of TAD or temporarily assigned duties, and internal candidates are favored. So what this is generally a recruitment statement. When the court is recruiting, if someone has been working out of class, it's called TAD, temporary assignment of duties, working out of class in that position, and then it gets posted, they're automatically included. So that's a benefit. So people, don't get the runaround if they are in fact performing that duty. And this happened a couple of times. And then also it's just a general statement talking about how if there's a tie between an internal and external candidate, the internal candidate is favored. So that's important to remember too. If you're ever on a recruitment committee or on panel A or B or C or whatever, however many panels the court determines, and there's a general consensus that these are the top two candidates and both of them are great, you be sure to mention, hey, one's an internal candidate, one's an external, we got to bend towards the internal. And that benefits everybody on the call. Salaries. We already covered this, 3% a year for every year. Good job, negotiation team. 4, this is really the sole takeaway of the contract. If The Kaiser copay is eliminated. For all other bargaining units, the Kaiser copay reimbursement is really what this should say, will be eliminated for SEMA as well. The court approached us and said, we'd like to just remove it. And our bargaining team said, no, if you're going to remove it from everybody, that's fine. If you're just going to remove it from us, that doesn't make any sense. And the argument that the court used was that this is an administrative burden. If there's anyone on the call that has to administer this, I'm sure that it is a burden, and I apologize to you. However, it really only stops being a burden if you stop providing it to everybody. We already talked about the public transit, so just know that there is a change to that. We increased the payment amount and discussed parking, which we hadn't previously. We also talked about the VRWH, the voluntary reduced work hours, and how that percentage was increased and codified in the contract. We talked a little bit about the training fund. Thank you for that clarification that it's 100% reimbursable for most types and only 50% for the memberships. And ready assignments, we also covered. Some people think of that as 24-hour pay, however you want to call it. We talked about that. And then we also talked about the increase, and this should read, to 40 hours in the management leave allotment, up from 32. And we covered that earlier. Okay, well, I know that was a whirlwind tour, so I apologize for the rapidity. I know I tossed a lot of information out to you folks. But hopefully that was a brief synopsis of some of the key features of the contract. And I'd love to stop, one, to catch my breath, and two, to give you all some options to respond. So if you want, you can unmute yourself and ask questions. You can put it in chat. For those that are joining on the phone, *6 unmutes you.
So I was wondering, Zeb, if you could share the document we just reviewed with you.
Sure. I'll pop that in chat right now.
Thank you.
Oops, I don't want to send that directly. Share with everyone. Okay. It's a Word document, so I did not format this for a PDF, but that's yours if anyone wants to do a thumbnail review there. Okay, I see a question came in. When bidding for vacation time off, how is it determined? By seniority with the court or within classification? So I'm not familiar with vacation bidding. Let me search for that in the contract. Can you clarify that a little bit more? Yeah, I don't see a provision for vacation bidding.
Hey, Zeb, this is Estella.
Yeah.
Figured I'd just talk. So when we have a group of people in the same classification and we're asking for time off throughout the year, if two of us want the same time off, who would get it? Is it based off of your seniority with the court or your seniority within that classification?
Sure. So it's not spoken to in the contract. If there is a departmental agreement, which I don't believe.
I know SEIU, or excuse me, Skippy, I believe theirs is spelled out in their contract, but ours is silent.
That's correct. And so for us, it's up at the determination of the manager. Whoever normally approves their vacation time, they can make that decision. As long as the decision is not discriminatory, it is allowable, right? So so there are kind of two factors here. And I've gotten involved on vacation requests a couple of times, but usually it's because they're not timely. There's not an obligation. Let's pretend you have two employees, right, that request the same week off. One is the most senior and one is less senior. There are so many variables, right? One put it in 4 months in advance and one put it in 1 week in advance, right? Well, then they're not like. One has already taken 2 months off in the year and one hasn't. So it really is, you're right, our contract doesn't speak specifically to that. and it's up to the manager as long as the manager isn't discriminatory and as long as the manager is not denying anyone that accrued benefit. So what I mean by that is, let's pretend I'm applying for vacation and I've maxed out my hours. Well, and the boss says you can't take any vacation. Well, now I'm hemorrhaging hours, which is a negotiated accrued benefit. That's not okay. Now, my boss may very well say to me, Zeb, you put me in a hard place because I now have to approve your vacation. I want you to take 2 or 3 weeks off so that now we've got some wiggle room, and every time you put in for vacation, I don't have to approve it. So that would be a very legitimate conversation to have. Long way of saying we don't have a specific thing spelled out in our contract. We could add that in the next contract cycle if that's a priority for members. Okay. I hope that answers your question, Estella.
Okay, Zeb. So I'm just texted Estella. So SEMA also doesn't have a policy that we need to submit an annual vacation request like Scipia. So I think that's where Estella is running an issue. Does the division then have the authority to say, all of you submit your annual vacation request like Scipia? Because if they are, then yeah, her question is valid. Then that if they all submitted all of their annual vacations, then they're kind of following Scipia's vacationing request policy. We don't have that. So technically, we shouldn't be bound saying we have to submit our vacation by October 15th of every year.
That's correct. If a work unit wanted to do that, they could open up a side letter discussion with SEMA. But it would be unreasonable for a particular unit or department to say, I'm implementing this, because that imposes restrictions on our vacation that we haven't agreed to. Right. So that it would not be appropriate for a unit to do that without union concurrence, because I'm characterizing it as a restriction. That's a restriction of when we can take vacation and when we can ask for it. That's not spoken to in our contract.
I mean, I'm interested in hearing from other members on this Zoom meeting. Are any of the other divisions are mandating that all of the members, only SEMA members, I'm not talking about Scipia, that are mandating that you submit your annual vacation all together at one time?
This is Sonda, and I'm going to speak for operations. We have supervisors. Right now, I'm the only DCM in criminal, so there isn't vacation bidding for my classification, but at least for the supervisors, because of coverage, we do have them bid for vacation. And that
You do have what?
We do have them bid for vacation. So it goes by seniority. We go just like Skippy, we do rounds of vacation bidding.
So okay, that I guess it hasn't been a problem so far, but that concerns me. I would not, and it sounds like, Laura, you're saying self-help does, meaning self-help also bids?
Well, what we do is we a year in advance, we select dates so that there's no overlap. And I think that might apply more in situations where you have multiple individuals in the same classification and we have coverage issues. So okay, we need to make sure there's somebody there. Now, we found a way to make it work for us. I know it's outside of the SEMA agreement, but it's kind of based on necessity that there needs to be some coverage and some manner of selecting who's off on that week.
And we'll talk about this in the CAC meeting afterwards. It's a great point that you all are raising where this is happening. I would really like to see it codified, because otherwise we'll get in, if this is, now that I'm being noticed of this, the court could make an argument of past practice, that they've been doing this with union knowledge for years, and then it just becomes a feature that maybe we don't want it to become. So we'll have to discuss that, but thank you for bringing this to my attention. And so it sounds like self-help. Georgia, did you say you do? Your unit does? What are the
No,
core-
that was me, Sonda. We're in operations.
Okay.
No, facilities is not. And anybody on IT, ISB, do you guys need to do that?
Bid. Sounds like not. Okay, but we're a little
That's a
bit
no.
over, but I do want to try to get to the other questions we have. So I hope you can continue to join us for a little bit. Someone just texted me that FCS does as well.
And then it was HR also. I think I saw the person who brought it up.
Well, that was the question from HR. I don't know if HR does. Does HR bid within the HR unit? We'll have to ask the court this question too. Like they may be aware of units that are, okay.
No, so that's why Estella brought it up, because she's in HR. So she's running into that issue. So I'm sure they do.
Okay, there's a lot of questions pouring in here. Let me see. Okay, Miss Hamlin, Kim, I think it's Kim. Sorry, Kim, if it's not. Sorry, Miss Hamlin. Is it possible to talk to the court about expanding teleworking after 70% of the community is vaccinated? Yes, we've already begun those talks with the CAC, and we've been, the court has stated that they're going to come up with a pilot program that they want to present to us. So we'll be looking at that and probably putting it to a vote of the unit once we get more of those details. It's a great suggestion,
Thank
though,
you.
and one that absolutely, it's a great suggestion. I think the world, or at least this nation, if not the world, is going to be a little bit different in terms of telework acceptance.
Great.
Elizabeth Derby asks, do we have any idea what to expect at the end of the fiscal year regarding whether the court will seek more furloughs or layoffs? I would say we have some idea, but I don't have an educated idea. What I will say is that the court has received much more money than anticipated from the state in terms of preliminary budgets and the preliminary budget projections. Also, folks, I just have to be frank with you. I do not understand this economy. I don't get it. I don't understand how we have so many people out of work. The county just announced that its property tax rolls have increased by 4.7% this year. And at the same time that revenues are growing, 37,000 households in Santa Clara County, households, which is way more people, as soon as the COVID rent relief and mortgage payment relief stops, they're going to be evicted. So I don't know how we have these increasing property tax rolls, increasing property sale prices at the same time that we have record levels of people that are out of work, and we have record levels of people that are not making enough to get by and not making enough to get help, right? It just really doesn't make sense to me. But that's where we're at. So court's getting more money in this budget. We'll have firmer numbers on that, but there's reason for budgetary optimism. So I think we'll go into the next fiscal year looking at a maintenance or mild expansion would be my guess at this time, but I will give you more information as we get more. I hope that answers your question, Elizabeth. Georgia, we talked about the vacation, like Scipia, yes. Self-help does, legal research does not, thank you. Thank you, Rowena. Out of employee necessity, okay. Okay, I think we covered all the questions.
Yeah. Well,
There was a news story the other day about the governor wanting to restore our pay cuts with extra money that they are talking about.
oh,
When you say restore, you mean add back funds
For this year.
Yes, that's correct. That's what I've heard as well, and what I've seen from the budget projections, as well as through our last conversation with the court. There's additional money being allocated with the idea of restoring cuts that were previously made to the court system in California. That's absolutely true. Is that Joe talking?
Yes.
Yeah, that's right on, and that's correct.
Do we know how that would affect us since we're still using our furlough pay? I mean,
So
furlough hours?
if we got that money, we could revisit the furloughs. but the furlough was in exchange for layoff protection. So if we were to eliminate the furlough, the court would logically be able to say, okay, then I'm not giving you a furlough, then I'm not giving you layoff protection. So we would probably want to do a poll of the membership if we wanted to do that. Our furlough protection, our layoff protection and furlough agreement is for 1 fiscal year. So the court would be within its rights to say, I'm not interested in talking to you about this until it expires. But we could certainly make that ask.
So if they're getting restored funding, shouldn't that come to us?
I mean, yeah, you could make the argument that it should, but it's not a feature of the contract, or the side letter, I should say. A feature of the side letter was if funding at a specific time, and I can find that side letter, if funding at a specific time was restored, which passed, then we would have a lessened furlough. But that time, the time horizon that the side letter contemplated has passed.
Yeah, I don't know if it could be applied retroactively.
It could, I mean, it could not unless the court mutually agreed to open it.
Correct. And it's kind of tied up, that issue's tied up in the contract with the protection that we got from layoffs. So I think we might be opening the door to potential layoffs. So I think it's more complicated than it seems.
But if they have extra funding, how can they lay us off?
That's the argument to be made. But I think we're talking about their even attempting to lay off.
Okay.
Right. It's the attempt, right? Because right now SEMA's insulated from layoffs, but let's say the court decides, guess what? I want to use that funding to add, I don't know what, a bunch of courtroom clerks. So I don't need these 10 SEMA positions. I need these 14 courtroom clerk positions. So that's what I'm using my extra funding for. But anyway, I mean, we would get into a longer discussion. We will certainly make that argument for all the members present. We will make that argument. I don't want to get people's hopes unreasonably up because we do have an agreement that stands for a year. So we'll make the argument. We'll look at the numbers, crunch the numbers, and see what the benefit is, and then respond.
So if I may, I just want to put out a big thank you to you, Zad, because you always have a wonderful way of explaining things. And I'm just really, really thankful that you were able to participate, put this together for us. I want to throw out something as well. One thing I'd like to have more of is just a connection between all of us. And with that, I would love to reach out to all of you who are on this conference call or the Zoom meeting, if you're interested in becoming a liaison. And the reason I bring this up is that we have different facilities, and I would love for each facility to have somebody present who other SEMA people could reach out to. We want a physical presence. I want to cast that net. So please reach out to me, send me an email. I'll put you on my list. And we have a committee next month. I haven't had a really short one today with somebody, a liaison committee meeting, but I would like to have it every month. It's going to, at this stage, we're looking at the 3rd Friday of the month at the lunch hour. And we're happy to open for possibly resetting it. If it's not a convenient time for everybody, we'll look at the majority. But send me an email. I'll put you on my list and send the link. And hopefully we can have more people connected liaison wise to make sure everybody is informed in every facility. So that was my little pitch. And I think we're all out of time for questions, but you can always email them to us. That's anytime. It's not just, after near the meetings, it's anytime. Send us questions.
Great.
Okay. So I think
okay, well, thank you all for attending. And in the next eBlast, this YouTube video will be uploaded. So your colleagues that were unable to attend that maybe want to learn a little bit more about the contract or hear some of your questions answered can access it. All right, thanks everybody and stay safe. CAC, I believe we have a meeting. Is that correct?
Yes, indeed.
I'll see you shortly.
Thank you very much.